Your Ladyship and my Lords, to invite you to paragraph 63, where the question that vexes you this afternoon is dealt with. At paragraph 63, they deal with a case which we've also supplied the court and my friends with. This is a well-known case of Senator Agostino Pinochet. But at paragraph 63, this is what they say. Also supply the court and my friends with. This is a well-known case
whether
of
it is perceived or actual,
Senator Agostino
undermines
Pinochet.
the public
But at paragraph
confidence in a
63,
judicial officer's
this is what they say.
ability
Supply the court
to
and my
defend
friends with. This is a
justice.
well-known
They then
case
cite
of
it is perceived or actual
Senator
in
Agostino
undermines
the public confidence
must be rooted in confidence, and confidence is destroyed when the right-minded people that Mr. Ndego was talking about go away thinking the judge was biased. At paragraph 65, the case of Webb versus Queen, in considering the merits of the test to be applied in a case where a juror is alleged to be biased, it is important to keep in mind that the appearance as well as the fact of impartiality have been done. And this is what they say at paragraph 66. And this, my Lord and Your Ladyship, is what I would be beseeching this court to find favor with when you retire to be a ruler. The rule against bias is as important an element of the right to a fair trial. This rule, and now this is our own pipe judgment saying this in the Court of Appeal, this rule is to be very strictly applied so that even the appearance of bias is done away with, the appearance alone. This is because it aids in public confidence in the fairness and impartiality of the judicial system. In view of the jurisprudential importance and uniqueness of this application, they then cite a case called R versus Sussex. Justice should not only be done, but should manifestly and undoubtedly be seen to be done. I will leave for you to read paragraph 67, which I also recommend to you. And then paragraph 71, another English case cited. First, actual bias will of course always disqualify a person from sitting in judgment. Even in the absence of actual bias, however, the importance of public confidence in the administration of justice is such that even the appearance of bias will disqualify. And this is emphasis added. And I would also invite you to look in the fullness of time to paragraph 73 and 74. Paragraph 81, they cite the case cited earlier, I think I mentioned it. This is the case of Agostino Pinochet. It actually begins at paragraph 80. There's a long passage, I'll not read it on account of time. But at paragraph 81, they cite the basis for the reason the two applicants before you have moved you. It's the Latin phrase, nemo debet esse judex in propria causa. No man is to be a judge in his own cause. Then at paragraph 82, Lord Hope, in the same decision, indeed, it may be said of all the various tests which I have mentioned, including the maxim that no one may be a judge in his own cause, that they are all founded upon the same broad principle, where a judge is performing a judicial duty, he must not only bring to the discharge of that duty an unbiased and impartial mind, he must also be seen to be impartial. Having considered all those, the court, and in that case, what the issue was that the late Justice Laka had represented one of the parties previously, not in this matter, but previously. But at paragraph 86, they give a summary of what I've told you, and then go to paragraph 88, and then this is how the court finally resolves the matter. And I would also recommend to you paragraph 90. Let me read paragraph 90 before going to the conclusion. The mere probability or appearance of bias was enough to breach the cardinal rule of fair trial in the administration of justice. Having raised the issue of bias arising from the same circumstances in the hearing of an interlocutory application by the same judge in a matter involving the same parties, we do not understand why the applicant's counsel failed to raise the issue during the civil appeal. That omission notwithstanding, the seriousness of the bias, of the issue of bias, cannot be underrated. As observed in the Benjo case, bias is one of the grounds that will justify review of a previous decision of the Court of Appeal. As I said, this was the first time it's ever happened in the history of the Court of Appeal, and as far as I'm aware, the only time it has happened. So at paragraph 95, this is what the court says. Accordingly, we allow this application, declare that there was a failure of justice in the judgment dated 4th October 2002,
and we accordingly invoke the court's residual jurisdiction to correct that injustice by reviewing the judgment and setting it aside with all the consequential orders. Now, my learned friend, Mr. Kibe, has referred you to a passage that my good and learned friends for the respondents insisted must be read. And this is the question of the attendance of a wedding where gifts are shared by a judge who, the gifts are received by a judge by a party who is before this court. We are before this court because the first petitioner was impeached in the Senate. The Speaker of that Senate is a party in this case. In the document presented by Mr. Kibe, the Speaker describes the judge, and there's nothing wrong with having friends, as I should say. I need to say this. He says, my long-time friend. This is what he says. Now, we found a decision, and I've shared it with you. This is the case of Naveen, where on all fours, a similar situation occurred. And I invite the court now to look at paragraph 70, and allow me to read this, because I won't be reading anything else after I read this. This is what the court, this, as I said, is Naveen Kerai versus Virunga Limited and others. I begin to read. I say paragraph 70, please forgive the coloration of the authority. And this is a 2022 decision. So both the Standard Chartered case and the case before you were determined under the current constitution. And as I'll be demonstrating here, they also took into account the judicial code of conduct. I'm reading from paragraph 70. In this matter, the third respondent declined to recuse himself. This was a matter of an arbitrator appointed under Article 159, declined to recuse himself on the basis that the relationship between him and the counsel for the first and second respondents was a professional one. This court, however, takes judicial notice of the fact that in the Kenyan context, invitations of colleagues to weddings is extended to those that one considers close, and such invites are not extended to all and sundry. Had that been the case, then the third respondent could have as well extended the invite to the counsel for the applicant, who is an advocate just like him. Given the circumstances, this court arrives at the inevitable conclusion that apart from being a professional colleague, the third respondent and counsel for the first and second respondents are friends. And that is the perception that any reasonable, objective, informed member of society would reach based on the circumstances of this case. I continue, paragraph 71. As counsel for the applicant stated, it is common knowledge that there is the custom for invited guests to give gifts at a wedding, exactly as happened in the case Mr. Kibe showed you. In this case, apart from the third respondent and the counsel for the first and second respondents, the applicants and their counsel will never know if the counsel for the first and second respondents was a gift-bearing guest at the traditional wedding or not. In this case, we know, because the photograph depicts a gift. It, however, boils down to the failure by the third respondent to disclose to the applicants and their counsel that he intended to invite the counsel for the first and second respondents to his traditional wedding and seek their views on the same. I need to emphasize that the real issue here is not that a wedding was attended. It is that that issue was not disclosed prior to the hearing and dismissal of an application in this matter and the continued conduct of these proceedings. I continue. Bearing in mind the final nature of arbitral awards, which can only be set aside upon a litigant satisfying the conditions stipulated under Section 35 of the Arbitration Act, the need for disclosure becomes even more critical. Paragraph 72. In S versus Roberts, the court stated that the apprehension be that of the reasonable person in the position of the litigant, and that is based on reasonable grounds. I continue at paragraph 73. The counsel for the first and second respondents has stated that since he and the third respondent are arbitrators who have served at the Chartered Institute of Arbitrators, Kenya branch, as chairman and vice chairman of the institute respectively, during the same tenure, they were bound to interact or have interacted in the Chartered Institute of Arbitrators events, trainings, board meetings, and members' welfare gatherings while discharging their professional mandate. I do agree that the above events are professional in nature. However, weddings are personal events where families, friends, and close colleagues are invited. The lack of disclosure by the third respondent that he had invited the counsel for the first and second respondents to his traditional wedding is one that leads to the perception of bias. Due to the failure to so disclose on the part of the third respondent, it has led to an erosion of the confidence that applicants have that he will be neutral when it comes to the hearing and determination of the arbitral proceedings before him involving the parties hearing. In conclusion, this court holds that there was lack of transparency on the part of the third respondent, and he should have done the honorable thing when he was requested through an application to challenge to recuse himself from the arbitral proceedings in nature. This court finds that the justifiable doubts have risen as the third respondent's impartiality and independence, and the same have been proved by the applicants. This is a decision, and the only one we could find that addresses on all fours the issue that confronts this court. I ask this court to find favor with this decision, to recuse itself, and I do so with tremendous respect. It's just that the nature of the matter, the nature of the issues, and the perception are such as are captured in that decision. Recusal would be the only thing that would do justice to not only the applicant before you, but to the court itself. Thank you for the privilege of your attention, for your time. Unless you have any questions, I'll rest at that point. And you have it. I sent it. Soft copy. You have.
Yes. My Lord, it is my humble submission that your lordships must exercise flexibility. The usual case law relating to recusal is inapplicable in the instant case. As a matter of fact, if I say to you very respectfully, if there are parties, and indeed there are, who do not want or who do not wish to see you hear this matter, please walk out. You are not the only judges in the country at all. Let another panel of judges be appointed to hear this matter. My Lord, if I may say so very respectfully, to refer to my own history, when you reach my age at your history, I remember there were one or two expatriate judges, colonial judges. The moment you said to him, to him, but your lordship, I would like you to hear this matter. I want you to recuse yourself. His response was, okay, if you don't want me to hear this case, let another judge hear it. That is the attitude you should take. Those of us who have had the advantage of receiving higher education know when you're dealing introduction to philosophy, you are taught that perception, the first course you take is perception and reality. Perception and reality. When you're studying philosophy, perception is a very important concept when it comes to the arena of politics. Reality may be completely different. And indeed, I believe it is different in the case before your lordships. I appear before you very often. I've never entertained any idea about your standing in relation to justice. But the perception now that has been painted by my able learned friends, clients, Mr. Ndegwa Njiru, Mr. Kibe, and Mr. Macharia, that there is a sizable portion of the Kenyan population which will not be happy to hear you sit and listen to this case at all. And may I remind your lordships very respectfully, impeachment is politics of the country. There's no way you can move away from that at all. I would respectfully refer you to a book I've taken the trouble to read.
Your Honor, sorry for the interruption. We are muted again. Perhaps you could be unmuted so that we follow the proceedings.
I wonder why it has happened in respect of Hamino. Can I speak now? Can I speak?
Yes, sir. You've not been muted.
Yeah.
Yes. Your Honor, there is a book here, Politics of Presidential Impeachment. Politics of Presidential Impeachment. I've taken the trouble during the weekends to read this book. Impeachment is politics of the country. There is no way you can remove it from the politics of the country at all. And that's why I'm saying, Your Lordship, very respectfully, that as you have been told, there are some people who feel very strongly that you should not hear this case. Get out. Let them get other judges to hear the case. You have no vested interest in the matter. There's no reason for you to remain in the case when other people do not want you to hear the case at all. May I remind you, my lords, when you are hearing impeachment cases, advocates should be able to think broadly and bring to your notice the culture of the people that you are serving. There is a little song there's a song that is sung by a little girl in Kenya. To those of us who listen to the Kenyan radio may have heard of it. He says in Kiswahili, Kenya ni nchi ya watu akili kidogo. He sings very beautifully. Kenya ni nchi ya watu kidogo. Na wanataka kitu kidogo ndio wafanye kitu. Majority of our people are not the people who are in this courtroom at all. Majority of our people are people who have not had the advantage of receiving the education, the training that the judges and the advocates and the members who are in this room at all. And as one of my learned friends very ably pointed out, majority of the people believe that the case before you has been engineered by the politics of the country. Indeed, if some of them believe that your lordships cannot hear them, again, I say to you very, very respectfully, you stand to lose nothing. You better leave the case, let other people hear the case, and you will continue to maintain your name. My lords, to go back to the politics of impeachment, this matter was first heard in the National Assembly. The National Assembly very overwhelmingly stated that the Deputy President had been impeached. It was then referred to the Senate, and the Senate again stated very overwhelmingly that the Deputy President was guilty and convicted him accordingly. My lords, the stories that one hears in the streets of Nairobi, the stories that one hears elsewhere You cannot afford to deny or ignore it. Stories like members of parliament were each given a handsome amount of money. That may be so or may not be so, but it doesn't matter. They have made a point that members of parliament received bribes and they handed down a decision which majority of people believe that it was a corrupt decision. You cannot afford to ignore that. Now, when you go to the Senate, you are told the same thing, that the members of the Senate received money in what is called, is it white bahasha or something of the sort, white bahasha. They received money from known people. Again, you cannot afford to ignore that at all. Now, when they come to the judiciary, they expect the best. They expect people who have got integrity. They expect people who can hear them and whom they cannot suspect at all. But if then they are suspecting some people, whether truthfully, whether honestly or not, it is my humble submission, the natural thing as a judge, if I was sitting where your lordships are sitting, I would say, as Khaminwa, I'm walking out. Do not sit. It is the judiciary that people have got confidence in. And as I may remind you, your lordships, very respectfully, it is the judiciary that the people of Kenya actually have respect for. It is the judiciary, the judges, that people think that can do good in Kenya. When we had a problem in the year 2007, it is the judiciary that saved the country. When we had a problem recently during the time of President Uhuru Kenyatta, and the matter went to the Supreme Court, it is again the judiciary that saved the country. Now, if you find that people now are questioning the very institution of the judiciary, it is my humble submission that as a judge, move out. Say thank you, I'm moving out. That does not necessarily mean that there is something wrong with you at all. And as I've said, my lords, I've spent many years appearing before your lordship, Mr. Justice Ogola, in Mombasa. At no time did anybody ever open his mouth and say to me that, Khaminwa, this Justice Ogola is this, is this, is this, is this. Nobody ever did it. My Lord, Mr. Justice Murima, I've had the privilege of appearing before you in many cases. There are cases where you have given me rulings. There are cases where you have not given me orders at all. But at no stage did I ever entertain an idea that there's something wrong with Justice Murima. We have confidence in all of you. But now we have this concept of perception. There are some people who feel very strongly that Justice Ogola should be out. Justice Murima should be out. My lady judge, may I say, I'm leading you, I'm not discriminating against you. I'm one who has fought for rights of women. And I kept on shouting very loudly that we want women judges. I have not had the fortune of appearing before you very often.
Actually, you have on a couple of times.
I was, oh, sorry. My memory is letting me down because of the age. Yes. But my lords, may I say, I have had the opportunity of appearing before you. And may I say this, my lords, if you go and check Judicial Service Commission records, you will not find a single letter from John Khaminwa complaining against any judge. I have never done such a thing at all. It's because I've got confidence in our judges. I've got confidence in our magistrate that they deliver justice. But I'm just saying you, my lords and my lady, if at this time we have some people who feel very strongly because they may not get justice before you at all, please walk out. Don't continue to hear the case. And indeed, the people who are saying that your lordships or my lady should not hear the this case, when they are speaking, you cannot really criticize them. They have got some valid complaints. My lords, United States of America, which I had the opportunity and the privilege of getting and studying their jurisprudence, they gave me additional legal education. United States of America, which has an impeachment provisions like Kenya, for 200 years, there is no president or deputy president who has been impeached, and the impeachment has succeeded. None at all. None at all. Kenya, a young country which got the first constitution involving impeachment provisions, came into operation in 2010, and in 2024, we are now being told the deputy president has been impeached successfully, has been found guilty. Is it unreasonable to suspect there is something wrong? Is it unreasonable to suspect that someone is doing something wrong? Gachagua may be a nut, may not be probably properly educated, but he's a deputy president of the Republic of Kenya. Why should he be the first one within such a short time to be impeached in the country? Can't you suspect there is something wrong, that you are not doing some things properly? That America, which has had impeachment provisions for 200 years, has never successfully convicted someone for impeachment at all, a politician.
Thank you, Dr. Kabinwa. Thank you very much.
My Lord, may I say thank you, but may I say with your worship's respect, I would appreciate if you would uphold my submissions. Thank you.
Just 2 minutes, my lords. In considering this application for recusal, I plead that you bear in mind the following. One, your brother, Mr. Justice Judge Mwita, your brother, Mr. Justice Mugambi, your brother, Mr. Justice Mwongo, sitting separately, each one of them was persuaded that the petitions and the notices of motion asking for conservatory orders raised weighty constitutional issues. That is why this bench was constituted. Those weighty issues await full arguments by both sides for the court to resolve. Number two, the weighty issues are around the petitioner applicant, the deputy president, challenging and seeking to have the impeachment quashed. In the interest of time, I will not restate those weighty issues. They are in the record before, but they are there. Challenging the impeachment and seeking to have the impeachment quashed. For the sake of this country, today and going forward, those are issues that must be heard and adjudicated by a bench that has no issues of bias, apparent or real, being raised against it. So for that reason alone, please accede to recusing yourselves so that another bench can be set up to adjudicate those issues. I thank you.
Very briefly, Your Lordship. My name is Kirago Aduta. I would like to talk about just 3 aspects on the subject of recusal, and I'll be making reference to 3 materials. I believe they've been circulated. That's a recent Supreme Court decision delivered on 11th of October 2024. Let me make arrangements so that they are brought, the copies. Yeah. Your Lordship, on my right and on my left are counsel who are involved in this matter where the Supreme Court was asked to recuse itself.
Which case?
This is Dari Limited and 5 others versus East African Development Bank. Mr. Nyamondi and Senior Counsel Paul Mito were on the same side, but today they are on different sides of that decision. When that application was made before the Supreme Court, I do not want to go through all what went on. I want to go straight to paragraph 27, where the court said, having arrived at the inescapable conclusion that we are being accused of bias and working towards an undisclosed predetermined outcome, we are strongly persuaded that our further participation in these proceedings will not serve the ends of justice, at least in the eyes and perception of the appellants stroke applicants. Consequently, and inevitably, each of us on this bench does hereby recuse him or herself from further participation in the hearing and determination of the appeal dated 25th April 2023 and filed on 26th April 2023. That's a decision that was made just when these petitions were ongoing. So when allegations of bias and working towards a certain outcome are made, what the Supreme Court recently is it recused itself. My Lord, I have a decision, an Indian decision. It's called State of Punjab versus Davida Pal Singh, which also the question of recusal was discussed at length. And again, I do not want to dwell. The whole decision is a very lengthy one. It's about 400 pages. But at page 9, at paragraph 16, the court set the standard that is applied in determining whether a bench should recuse itself. And the test, I read, the test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and whether the adjudicator was likely to be disposed to decide the matter only in a particular way. The court went on to say, the court has to proceed observing the minimal requirements of natural justice, i.e., the judge has to act fairly and without bias and in good faith. A judgment which is the result of bias or want of impartiality is a nullity, and the trial coram non judice. Therefore, the consequential order, if any, is liable to be quashed. Lastly, and this is what is very important, at paragraph 18, the court said in part, however, if there is real ground for doubt that doubt must be resolved in favor of recusal. So that, my lords and my lady, if you are in doubt whether you should recuse yourself or you should not recuse yourself, that doubt should weigh towards recusal. That decision will be shared. And then the court went on to quash some proceedings which had taken place, an appeal had been determined, and then this one went all the way to the Supreme Court of India. So the court said that that is how situations of bias are treated. I had reference to the code of conduct of judicial officers. I think that's what Mr. Dego was referring to. My Lord, I want to lay the basis as to where those provisions are obtained from. And those provisions are obtained from the IBA guidelines on conflict of interest in international arbitration. You will find that material is published by the I located it from the International Bar Association, and it was done first in the year 2004, and it has been applied worldwide as a guide on determining situations of conflict of interest. And it has graded conflicts in several shades, the traffic light shades. There's green, there's brown, and there's the waivable, non-waivable, waivable, green, and the brown. And at clause 2.37, one of the situations that is a waivable conflict is the arbitrator has a close family relationship with one of the parties or with a manager, director, or member of the supervisory board, or any person having a controlling influence in one of the parties, or an affiliate of one of the parties, or with counsel representing a party. Going with the materials, if they are true, that was stated by my learned friends, then that situation has already arisen, and therefore it is a good ground for recusal. But I don't want to take much more time, but these materials will be circulated. There is much more in these materials that speak towards recusal in the situation that is now given. Thank you very much, Mr. President.
Sorry, Counsel, does the court have the benefit of the authority that you have referred to, the Punjab case and the IBA guidelines?
The Indian and the Supreme Court case?
Yes, and the IBA guidelines, have you supplied?
They have been brought shortly. Yeah, thank you.
How many more?
Your Honor, I also wish to say something on behalf of the second petitioner in 565. If I'm allowed to proceed.
Who are you?
Can you see me?
Your name?
I'm virtual. I'm online.
What is your name? What is your name?
Kimodo Teresia Wanjiro Makazi from Kilgoya.
Yes, proceed.
Yes, thank you. I just wished to support that application by just submitting that public perception is everything and it cannot be ignored. I wish to rely on Article 47(1) and Article 50, and more specifically in Article 47(1) is where it says that every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. And more specifically on the part that is procedurally fair. Yeah, if you look at the way the court has conducted itself, Of course, we are competent enough to handle these petitions, but then again, on the issue of the procedure, we had raised an issue of service, and the court ruled that we should check all documents in the portal. Unfortunately, today, you could not access the e-filing portal. So what one is meant to wonder is why we were told to access documents online, and when we go to the portal today morning, it's not working. Therefore, there is this perception that perhaps there could be something going on, because at all material times, judges shall be impartial. And the issues being raised currently are that there is an issue. Sorry? Okay. So there are issues that are being raised that are raising issues to conflict of interest, whereby we have been directed by the applicants to note that one of the judge has a spouse who has been nominated or appointed by the President of Kenya, His Excellency William Ruto. And I think that is not a question where we should be giving out affidavits. I think that is a question where the judge, the honorable judge, should just come out and tell us, if this is true, then are you going to feel conflicted? So that we can, as petitioner, say, okay, proceed, or no, let's have a neutral bench. The other issue is the issue of another judge, Honorable Justice Murima, being seen. No, not the judge. I'm not saying the judge. I'm saying the spouse of the judge being nominated or appointed. That's the issue that has been raised by the applicants. And so we feel, of course, if this appointment was done, will he be able to Rima attending a wedding ceremony, Kingi? So the issue is, and they are long-time friends, will he be able to disappoint a friend? You know, these are the issues that the public is asking, and it's the perception anyway. So in issues such as this, we say these issues are very important and they cannot be ignored. And there's no point of, if people are saying we don't want the bench, it's not so hard for the bench to say, okay, just let's go back to the Chief Justice, please appoint another bench. There's nothing wrong with that. We know the judges are competent enough, but then if the issue of conflict of interest is arising, then the best thing to do before we go to the substantive issues is to pen everything down and say that go back to the drawing board and appoint a new bench. That's all.
Yeah, please, Your Lordship. My name is Daniel Manzo. I do appear for the third interested party, and I recuse myself. My Lord, I ended up in an out-of-court settlement. I do ask Ms. Akala to conclude.
My lords, my lady, I just make one submission that in light of the disclosure about the relationship between Justice Murima and the Speaker of the Senate, we find ourselves in a very unfortunate situation where the bench looks like it's on trial. Motions of recusal are normally very difficult to prosecute because the question is, and this is a question that respectfully I want to pose to the bench. Will you feel comfortable? Do you appreciate the fact that so far, the events that have taken place, whatever determinations that you will arrive in these particular matters, and they are weighty constitutional national matters that affect the entire country, are you satisfied that they will be received well by the public? That's a question that should be in the mind of the judges as they decide whether to recuse themselves or not. Secondly, it is very clear that the only mistake here was that Justice Murima did not disclose a relationship between himself and Amason King, which is out of a friendship and which is not even illegal. But disclosure, the mere fact that there was no disclosure by itself creates suspicion, apprehension in the minds of the applicants. The last question is, if Justice Murima decides to recuse himself, is it the entire bench that will recuse itself, or only one judge will recuse himself? Because I'm convinced that inevitably Justice Murima must recuse himself. Thank you so much.
Your Lordship and my lady, if it may please you, my name is Akimpa. I do appear for the third petitioner in the consolidated petition. Your Lordship, mine is just to put into context the Supreme Court decision in Dari and 5 others versus East African Development Bank. So, Your Lordship, in that particular matter, I want to say that, first of all, it was before the Supreme Court, and notwithstanding the doctrine of necessity, the Supreme Court considered that the right to a fair hearing by an impartial tribunal was so sacrosanct that the Supreme Court did not even consider the doctrine of necessity. So I just want to read paragraph 26 where the Supreme Court said, what is undeniable is the fact that by resorting to this course of action, the applicants are unequivocally accusing this bench of lack of impartiality, fairness, and integrity. Such an accusation against a judge goes to the very core of his oath of office. Coming from a party to ongoing proceedings, such an allegation must strongly persuade the judge to recuse themselves. So that is what the Supreme Court said. So, Your Lordship, in that particular paragraph, the Supreme Court is saying that if there is an allegation, especially because this instance is actually almost same to that, because there was a complaint that was lodged against that bench before the Judicial Service Commission. I have heard today that the first petitioner has already lodged a petition before the Judicial Service Commission. Your Lordship, I beg that you are guided by this decision in holding that the right to a fair and impartial tribunal is very key.
Thank you, but I think you should let us know about the petition which has been lodged, because I don't think parties are aware of that.
Your Lordship, I think it is in the further affidavit.
A petition?
No, not petition.
What is it?
A complaint that was made.
Don't mislead the public. There's a whole difference between a complaint and a petition.
Yes.
Don't mislead the public.
He is the one who has said petition. He said complaint.
All right.
Thank you.
He's on our side.
Where are you interviewing?
May it please the court. My name is Dr. Eboso. I'm from Vihiga County, and I'm petitioner number 11 in the consolidated petition in the cohort 1. As I sat as a petitioner who essentially had no issue with the sitting of the bench, because when a petitioner files a petition, there is a presumption that the bench is properly constituted, and that Kenyans elected the Constitution of 2010, and in it provided the independence of the judiciary and the conduct of the expected conduct of judges. And therefore, we as Kenyans have trust in the judiciary and the individual judges at the time when they are appointed and during the course of their performance. But as I sat, I agonized over the issues that have been raised, and at the outset, I realized that the recusal application has been made to this bench to recuse itself, or some of the judges to recuse themselves, but as a decision of the bench. And I agonized over whether recusal or the place of recusal proceedings in a setup like ours. And perhaps this was amplified by the back and forth that we saw with regard to the facts that were coming out. And I would wish to be persuaded by Minwa that really recusal proceedings and the kind of facts that come to light ought not really be a subject of litigation for several reasons. One, recusal proceedings are really against individual justices, and they relate to the personal conduct, which really lies in the mind and conscience of the individual judge. I would give an example. Suppose we ask the bench